number 72, Henry versus Hamilton Equities. Counsel?
Thank you, Your Honor. May it please the Court, Your Honor, my name is Alan Friedman. I represent the appellant, Carol Henry, in this case. I respectfully request 3 minutes time for rebuttal.
You may have 3 minutes, sir.
Thank you, Your Honor.
Welcome.
Your Honors, there are two separate grounds why the Appellate Division First Department should be reversed. The first ground is that the Appellate Division First Department incorrectly added another prong to the second restatement of torts, which this Court adopted in Putnam versus Stout in 1976. The second reason this Court should reverse the First Department, Appellate Division First Department, is that the respondent was never truly an out-of-possession landlord because they had a non-delegable duty to continue to keep the property in good repair. In 1976, Your Honors, this Court adopted...
What did they add to the first prong?
Yeah. Well, the first prong, Your Honors, is that, as this Court knows, the second restatement of torts, where a party contracts by covenant in the lease or otherwise to keep the land in repair.
But doesn't that prong of the restatement say the lessor as such has contracted? So what does the as such mean?
Well, the or otherwise. Or,
to me, it means the lessor as a lessor has contracted. Or otherwise, the lessor, I think there are cases, can do it in orally. They don't have to do it in a contract, but they still have to be doing it in the capacity of lessor. That's what as such means to me in that provision.
I don't disagree, Your Honor. But what happened in this case...
But then the one that you want to incorporate is from a mortgage. They're not acting as a lessor when they make that representation.
I'm not trying to incorporate from a mortgage, Your Honor. This is a regulatory agreement that was entered into between the lessor and the federal government.
But he's not acting as a lessor there.
In a sense, they are, Your Honor, because what the purpose of HUD is, the core mission of HUD is to promote sustainable housing for the express purpose of building communities and improving the quality of life.
Yes, but they do that by loaning money or guaranteeing mortgages and providing buildings that can be kept up, right?
Well, yes, Your Honor, but the whole...
And their purpose is to make sure that the property that's being mortgaged is kept in reasonable repair, and if it's not, their agreement with the mortgagor says you're in default of the mortgage, right?
No.
Or you're in default of our agreement, but there are consequences to that, but it doesn't say anything about third-party liability.
Well, if I could respond, the restatement of torts looks at it from the landowner's responsibility to the public. It doesn't look at it from the injured person that's injured. From their perspective, do they have a benefit? Do they get a benefit to sue? The restatement of torts looks at it from the landowner's responsibility to the public. And as I just previously said...
So you're not arguing then that the plaintiff is a third-party beneficiary of this contract between HUD and the landlord/lessor?
No, I'm not arguing they're a third-party beneficiary. In fact, the restatement of torts was, the modern trend as of 1976 was to do away with the necessity of privity. And they're not necessarily a third-party beneficiary, but...
Let me just ask you about that then. It seems to me that you're arguing that the contract creates a duty on the landlord's part to keep the property in good repair. Am I right about that?
Absolutely.
And that's where the tort obligation arises out
Yes.
of this contractual relationship, and the contractual relationship is based in a desire to keep a mortgageable asset in good repair, right?
Absolutely, Your Honor.
So how does it, to follow up on Judge Feynman's question, how is that not then creating through a contract, like an Espinal, a third-party beneficiary problem for us? Tell me why that this isn't the creation of a third-party beneficiary to that contract, how this tort duty is different from the contractual duty. Explain that to me.
Well, if I may, Your Honor,
Go ahead.
My understanding is in the restatement of torts, in Putnam versus Stout, did away with the outdated modes of there had to be a contract between parties for, in this case, Ms. Henry to bring a lawsuit. Mm-hmm. And and the court adopted the restatement of torts, the second restatement of torts. So there is no necessity of a contractual relationship. where Ms. Henry would be a third-party beneficiary of a contract. There's no need for that contract anymore pursuant to Putnam versus Stout. Now,
But when we,
just-
when we overruled Cullen in Putnam and essentially adopted the second restatement of torts, we relied on certain policy reasons, didn't we?
yes, Your Honor.
Okay, so tell me how those policy reasons are furthered here. How in any way we're worried about the tenant's ability, the financial ability to make repairs, how there's any evidence in the record that that Grand Manor relied on anything in any agreement between the owners and HUD to refrain from making repairs, when in fact there was this escrow fund, and they went into the fund all the time, and they got permission of HUD, and they made repairs, and everybody knew that's what was going on. Nobody ever went to the owners and said, you make these repairs.
Well, Your
Right.
Honor, I believe they went to the escrow fund one time to make the repairs. That is correct.
One time?
I think it was one time, Your Honor, that they went to. It wasn't more than one time. One thing about the legal liability to a third party is a financial consideration, which is a social policy issue. In this case, as Putnam versus Stout, again, this wasn't addressed by the First Department. Legal liability to a third party, in this case, Ms. Henry, is a financial consideration, which was discussed in the lower court, in the First Department Appellate Division. This is 46 years later, also than Putnam versus Stout. Social issues have changed. And the purpose and mission of, like I said before, of HUD is to promote sustainable housing for the express purpose of building communities and improving quality of life. But there's also other vested interests.
The way I understood the issue is that I thought the First Department was saying that if the contract had been between the owner and the tenant, then the duty would have been created. But here the contract was not between the owner and the tenant, but between the financier and the owner, and therefore the duty wasn't created. So the question for us then, and you can correct me if you think I'm wrong, because I don't know if I know the answer to this question, but it was a duty created in tort, or was a contractual obligation created as a result of this contract that only extended between HUD and the owner of the property, as opposed to once you made that contract, you had a duty to anyone who uses the property that you own, like you would in any other situation as an owner. That's the nub of what I see as the problem here.
Well, there's two points to that, Your Honor.
Mm-hmm.
Number one is the lower court talked about first, the restatement of torts, again, I said this before, puts the duty on the landowner, looks at a perspective from the
That's clear.
landowner, not does the...
Right, no, you're right about that. The only question is does that duty extend here when the contract is not between the owner and the tenant? And there's case law in the lower courts that seem to go both ways.
Well, I will say this, Your Honor. Number one, it does extend, because this landowner was getting a benefit. They want all the benefits, but without any obligation to the public. They're getting public money to build this.
What about the circumstance where the landlord makes an agreement with the tenant to clearly transfer all responsibility for repair and maintenance to the tenant?
Well, that's not the case here. This is a regulatory agreement. May I finish my answer?
Yes, please.
In the context of this case, Your Honor, the regulatory agreement put the burden on the landowner to continue to take care of the property. And there are a lot of social issues that exist now, such as other vested interests, Medicare and Medicaid in many cases. So this will have far-reaching implications, because Medicare and Medicaid now has clawback rights in many cases to get their money back for when they pay for health benefits for people that are injured by landowners. So this will have far-reaching implications of public money.
What would be the remedy that HUD would have for a violation of those terms? What's the remedy under the agreement the landlord has with HUD?
Well, I think there are a number of factors, if I could, it's not a direct answer, Your Honor, but I'll try to answer it the best I can.
How about a direct answer?
I'm sorry?
How about a direct answer?
I will
Like, what
I will
are,
try
under the
to.
contract,
The point is,
what are the remedies that HUD would have for a violation of this provision? Aside from whatever liability they might have to a tenant, what is HUD's enforcement ability of that provision? What can they do?
Honestly, Your Honor, there was nothing in the regulatory agreement that I read where there were any.
Well, what are the consequences of the landlord here, this party, violating the HUD agreement? What are the consequences generally for violations of the terms of the HUD agreement?
Well, in this case, the third party, if the property is not kept in repair.
No, but there are other provisions, other covenants, I'm assuming, in the HUD agreement. What are the remedies, what enforcement mechanism does HUD have if this party, the landlord here, doesn't comply?
So for example,
Fair enough.
sometimes a bank and a mortgage says, if you let the property go to waste, we're going to come in and we're going to make the repairs, and you're going to be responsible for that in addition to whatever you borrowed.
Well, in this specific case, Your Honor, what happened was, I could speak to the facts of this case, HUD actually went in and conducted inspections of the property. And they issued reports. And those reports were not sent to the tenant, they were sent to the landlord, in this case, the Hamilton companies. And my understanding is there would be fines that would be imposed in this case. But that's just one of the remedies. And if we look at it, as I previously stated, and if I may finish my answer, the legal liability to third parties is a financial consideration. And there are so many other, as I said, social policy issues that exist today where there's clawbacks in Medicare and Medicaid and other interests that have a lawsuit, not just Ms. Henry, through Ms. Henry, other entities.
Counsel, isn't it also a consequence that if you breach the terms of these kinds of agreements, that you will not be able to get any more of these federally subsidized loans? You're basically going to be put out of business.
I would agree with that, Your Honor. I would agree with that.
Thank
but-
you, counsel.
Thank you.
Thank you. Counsel? Counsel, what difference does it make if the landlord makes the promise to keep the property in good repair in an agreement with the tenant or with a third party?
Well, first of all, may it please the court, my name is Michael Tricarico, and I represent some of the respondents here. I just wanted to make one point clear before I answer that question. The respondents that I represent are Chait Hamilton Management Company, Hamilton Equities, Inc., Hamilton Equities Company, and Susan Chait Grant as administrator of the estate of Joel Chait. And Chait Hamilton Management Company is not a party to this appeal because the plaintiff and appellant has agreed not to pursue the claims against that entity. Now, I'm sorry, what was your question?
So my question is, what difference does it make if the landlord makes the promise to keep the property in good repair, and that promise is in an agreement with the tenant or with some third party?
Well, I think that creates a very significant problem, and I think that if the court were to decide that the plaintiff has a cause of action based upon that, it would basically undo significant precedent in the area of property owner liability as well.
Tell me where it is in your contract that the language is that limits this duty to a relationship between HUD and the defendants. The duty to keep it in good repair once it's created, is it limited by contract in any way?
Well, the duty to keep the premises in good repair, the consequence of that, I think, to get back to the question that Judge Garcia asked before, and I think that answers your question as well, is that it's an acceleration of the mortgage. So basically, HUD is guaranteed the mortgage.
That's the penalty for failure to do it.
Yes.
But my question is, as opposed to the contractual relationship between the parties, and I understood the judge's question that way, what I'm concerned about is, does that contractual duty, once that duty is created through a contract, is it limited in any way to whom it extends to?
Yeah, I think it's limited. Actually, there's federal case law on this, and actually there's a case that I've cited in my brief that is actually between Grand Manor and Hamilton, and that's a federal court case at 94 F sub 2nd 406. And in that case, it deals with the issue, and it talks about who is the intended beneficiary of these HUD agreements. And what the court concluded there, and basically all of these cases with HUD involving regulatory...
Is this a Second Circuit case?
That I apologize if I said Second Circuit, I meant
No, it's
Southern
okay.
District. But is a trial court case in the Southern District. What you find is these HUD cases tend to appear in federal court because HUD can remove the cases to federal court. But in any event, they dealt with not only HUD agreements in general, but the HUD agreements that were at issue in this very proceeding. In fact, as the court knows from the request that I've made, that it take judicial notice of certain information in that case, there are actually two HUD agreements. There was one with Grand Manor, and there was one with Hamilton. And the Hamilton one is an exhibit that's been marked in this case. But in any event...
Isn't it a fair way to look at those, that each of them represents an independent obligation that HUD sought from both Grand Manor and Hamilton?
Right, and what's interesting about that in the federal case that involves the two parties is basically involves Hamilton and Grand Manor. Basically what they said is that those regulatory agreements exist solely for the benefit of HUD. And
that's in terms of who can enforce them, is that right?
That's in terms of who can enforce them and who has rights under them. Because
are those the same questions? And that goes back to Judge Fahey's question. That is, if someone is a third-party beneficiary to a contract, that person has standing then to enforce the contract himself or herself. But somebody might be the beneficiary of a duty, not have any ability to sue to enforce the contract. So, for example, the plaintiff here couldn't have sued saying the conditions are unfit. But if injured by the duty that's created, that person might be, I'm not saying is, but might be, covered by that duty.
I don't think so, because I think the courts below and the court in the Southern District dealing with this issue and other federal cases that have dealt with it basically say, and the court expressly said this in the federal case that I'm talking about, it said that neither party has any rights to enforcement of the other party's contract. So neither party is an intended third-party beneficiary of that contract. The only beneficiary of it is HUD.
Yeah, but that doesn't go, I think, to the point that's being made here as to whether or not someone who's injured, who's not a party to that contract, can seek to get some kind of civil relief,
well, I think
monetary
then,
relief or otherwise.
I think then you would be extending third-party beneficiary law in the state of New York well beyond
Well, but
whatever,
I think that
what it is.
That's really what we're arguing about. But let me ask you a different question. I want you to explain to me what your client's view and your advocacy on this is of the state of the relationship between the lessor and the lessee post the amendment to the lease. That is, after the regulatory agreements, after the agreements with HUD are entered into, now you're now subject to these provisions, what effect did this amendment to the lease have?
In all honesty, to tell you the truth, Your Honor,
That would be a good thing, yeah.
as a practical matter, it didn't have much of an effect because...
Well, doesn't it at a minimum put the lessee on notice that the federal agreement supersedes the lease if there's a conflict?
I think I don't think it's a conflict, and I don't think it's an inconsistency, which is the term that's used in the amendment. I think that clearly the parties didn't treat it as an inconsistency, and
well, if the lessee says if the lessor is saying, I have no duty under the lease, and the argument here is that the federal agreement imposes a duty, don't you then have a conflict?
No, I don't, because I don't think the federal agreement imposes a duty. I think ultimately we do have a duty to...
If we disagree with you, do you lose?
I don't think so. I don't think so. If there's a conflict, like I said, if you find that these two things are in conflict, I don't think that we lose, because I think that...
Does it make a difference whether HUD recognized that the defendants could delegate their duty to a third party as long as the property was kept in good repair?
Yeah, and I think that's the key question here. Actually, HUD, as we know from the federal case that I was talking about between Grand Manor and Hamilton, HUD actually entered into a separate regulatory agreement, which I've asked the court to take judicial notice of, which is in the record of the case that I cited, and it's in the docket at 12 Civil 04916.
Yeah, but that doesn't in any way state that it relieves the lessor of their promise and covenant to HUD.
Right. Well, I think to answer your question simply, what happens here is I don't think that and it's clear from the two regulatory agreements that we have the ability to delegate someone to perform the repairs. However, if they don't perform the repairs properly, we bear the consequences of what the agreement with HUD tells us, and that is a foreclosure or acceleration of the mortgage, not liability to some third party that gets injured, because, as I said before, the tenant is not a third party beneficiary.
Basically, a breach of a contractual duty is not the same as a breach of a duty in tort.
I think that's correct, and I think
mean, at
that
a very basic level.
right. And I think
All right.
well, and I think
so. Can we decide this case without actually getting into consideration of the purpose of the HUD agreement?
Well, I think it's all relevant based upon the arguments that have been raised by the appellant here, but clearly the stated purpose of the HUD agreement by their own expert and by the lower courts is to protect the physical property and its fiscal integrity. But yes, I think
But the way it does that is by requiring something of the landlord, which is this duty to maintain the premises in good condition.
Right, and the consequence of that is, like I said, if it does not, is an acceleration of the mortgage, not
Yes, but we've adopted the restatement, and the restatement says if you agree, the landlord agrees to be responsible for repairs, that they're responsible to someone who's injured as a consequence.
Well, I think that the way the restatement is written, and I think that Judge Garcia touched on it before, talking about responsibilities as a lessor.
Yes, but that goes to the first provision, actually adds nothing, because it says the lessor as such has contracted by a covenant in the lease, but that is how the lessor would contract pursuant to a lease in the position as a lessor. The question that's raised is what the rest of it means, or otherwise.
Right, or otherwise, I would submit that the lower court got that correct, and it has to be...
Well, what's the point of or otherwise?
Because it can be outside of the scope of the lease. For example, there are cases in the lower courts that illustrate that. The landlord says to the tenant, don't worry, I will shovel the snow off of your steps, during the winter. I will be responsible for repairing the driveway. It's not in the lease, but it's a communication outside of the lease where you have assumed that responsibility. It's really all about a manifestation of intent.
Without saying anything.
Yeah, in some ways, I guess conduct could be, but I think that conduct is evident of what your intent or what your communication was to the lessee. For example, if you're a lessor and you're going to agree to repave the parking lot in a shopping mall like is discussed in Putnam, you're not going to just show up one day and start repaving in all likelihood. You're going to tell the tenant, look, the parking lot's in bad shape. I'm going to take on the responsibility of performing that, and I'm going to fix it.
Thank you, counsel. Counsel?
Thank you.
Welcome.
Sorry, one second.
Take your time.
Counselor, can you point to any cases in which we have applied the Putnam rule to an agreement between the owner and someone other than the tenant?
Well, Your Honor, the trial court actually mentioned that this is a case of first impression. In this case, we have a regulatory agreement.
So we would be creating new law. You're not basing this on Putnam or any precedent of ours.
Well, that could be answered I have two responses to that, Your Honor. You're not creating new law, because what the court has already done, it's already adopted the second restatement of torts that puts a duty on the landowner to keep when they enter into a contract to...
But we've never said what that or otherwise means, right?
That's fair, Your Honor.
And if we were to say what you say it means, we would be creating new law in the state of New York, because we have never applied that language in that way so far.
I think the court, would be defining what or otherwise means. But as well, Your Honor, in the specific facts of this case, when there's a regulatory agreement, in this case, the landowner had non-delegable duty to continue to take care of the property. So they're not even really an out-of-possession landlord.
That's the conclusion that you want us to reach, is that it's non-delegable.
No, it is.
That's the question that we're here to answer. That's not specified or explicitly stated anywhere.
Well, actually, there's an expert's report, I think his first name was Mark, Mr. Cleon, K-L-I-O-N, where he was a commissioner for the Department of Housing and Urban Development, and that's part of the record, where he said that these regulatory agreements mandate a non-delegable duty upon.
That's his
landlord.
opinion, and that coincides
And
with
that's
your
in
opinion.
terms of HUD's perspective on this agreement. What I have a problem with in all this third-party duty talk is it disassociates this from Putnam, because this isn't a general contract issue. In Putnam, we changed the law where you could have an agreement between the landlord and the tenant, and then somebody was injured, and we were saying even that didn't create a third-party obligation to the person who was injured, and we changed that rule. It wasn't a contract rule. It was an out-of-possession landlord rule, and we changed that rule. So now I think you have to look at what are we making this change to. It's not, well, we're going to examine this as, well, is this a third-party beneficiary of a HUD agreement? This is, are we going to extend that Putnam ruling to encompass agreements between an out-of-possession landlord and someone else besides the tenant? And that, as I think Judge Stein is alluding to, is a big step, and I don't see any other state that's done that.
Your Honor, this is not just any other party that the landowner agreed to. This was the federal government.
So it would be a rule that where you make a third-party agreement with a federal regulatory agency?
Well, I think that's a factor to consider. I mean,
So what
Putnam
would the
versus
rule
Dow-
be?
I'm
What would
sorry?
the third-party rule be?
Well, I think the third-party rule would be I think the court would just be not necessarily expanding on the restatement of torts. It's just reinforcing the restatement of torts. The first prong, where where the landowner contracts to continue to take care of the property. You just
Well,
reinforce it.
let's take a step back here. In New York, third-party beneficiaries can receive a benefit that they have not contracted for in a tort situation under the Espinal, I forget the full name of the site, and there are a specific series of, and I'm not sure of the rest of the site, Judge, but there are 3 rules they set out, and those 3 rules I don't think you're arguing apply here. So the Espinal third-party beneficiary rules, you're not saying they apply in this circumstance, are you?
Absolutely not. I'm not playing
Okay.
Espinal.
So, but in point of fact, third-party beneficiaries who are not parties to contracts can benefit in a tort-like situation to a contract. The classic example is a snow plowing contract, those kind of situations. You're familiar with that, right?
Yes.
Okay. So the question for us, though, is a little bit different. Here, we're talking about an out-of-possession landlord who has a contract that's unrelated to the beneficiary of the contract, and whether or not the duty that arises between those two, or as Judge Feynman put it, the contractual obligation that arises between those two extends to the third party, the plaintiff in this action. So the question still goes back to, is a tort being created here, or is it simply a matter of contract law?
Well, it's not a matter of contract law, because contract law, I noticed my time expired.
You may,
Thank you,
please.
Your Honor. As this court knows, that in Putnam versus Stout, you did away with the necessity of privity. So,
No, I'm not saying there has to be privity. I think the third-party beneficiaries can recover. I think you're totally right about that. The question is, under this contract, can they recover?
absolutely, Your Honor. Even under, there was a case decided in the First Department by the name of Rojas versus.
And if they could recover, let me ask this, I accept that, let's say they could under contract. They could only recover under tort law, right? Not under contract law.
Under tort, yes.
Okay, thank you.
Thank you, counsel.
Thank you, Your Honors.